5 seconds to go. Start. This greatly annoyed them as they thought of themselves as the Chaudhary of the village. This had led to an altercation and an exchange of hot words between the two sides on the previous evening, but the matter was then patched up by discussion. He finally stated that the accused, in a league with one another, had killed his brother Dinesh by giving him knife and lathi blows. After the occurrence, he brought Kamlesh to the civil hospital Kanpur, where he was declared brought dead. Dr. Pawan Kumar, PW3, who was in the hospital on duty, sent information in that regard to the SHO PS Keshopur, whereupon PW8 came to the hospital and took down the statement of the appellant. The FIR was delivered at the residence of the area magistrate on the same day. What is, however, of significance for our purpose is that the trial court disbelieved a substantial part of the prosecution story. The trial court did not accept the prosecution case that accused were present at the place of occurrence and accordingly directed their acquittal. As regards the trial court pointed out that the three incised wounds on the person or the deceased that were attributed to him were, according to the medical evidence, post mortem in nature, that is to say, those three injuries were inflicted after Mahesh was already dead. The medical evidence thus clearly eliminated the participation of Rakesh in the case. He too was therefore acquitted. The acquittal of the three accused brought down the number of the remaining accused for the shared common intention with the appellant. Apparently, that was one of the reasons for their conviction simply under section 323. Apart from the three accused whose presence at the place of occurrence was not accepted, the trial court also doubted the presence of two out of the three eyewitnesses. The trial court further held that even PW2, the only remaining eyewitness, had mixed up truth with falsehood, but his testimony was not liable to be discarded wholly, since he had himself received injury in the same occurrence. In regard to the injury, the trial court came to a truly amazing conclusion. The injury on the hand of Rakesh was certainly in existence, and it was also proved by the medical evidence. The trial court resolved the contradiction by fashioning the injury to Rakesh too. The appellant was thus held guilty also of causing the knife injury to Rakesh and came to be convicted under section 324 in addition to section 302 of the Penal Code. Under section 324, he was sentenced to rigorous imprisonment for 1 year. He was also convicted under section 25 of the Arms Act by a separate judgment of the trial court dated February 2, 1998 in Sessions case number 26 of 1993 and sentenced to the period of imprisonment already undergone as under trial. Against the two judgments of the trial court, three appeals were filed in the High Court. The High Court, by the judgment and order coming under appeal, dismissed all the three appeals and the revision, and thus upheld the judgments of the trial court in all aspects. Mr. Sahai, senior advocate appearing for the appellant, assailed the High Court and the trial court judgments and contended that the appellant's conviction for the offense of murder was not sustainable both in law and on facts. Mr. Sahai submitted that there were at least four circumstances that falsified and completely demolished the prosecution case. First, there was a patent contradiction between the prosecution case and the motive assigned by it to the accused for committing the crime. Secondly, it was undeniable that injuries were fabricated both on the person or the deceased and Rakesh, the only eyewitness whose evidence was accepted by the High Court. At the time when the plea was raised before the High Court that the impugned orders are vitiated on account of the non supply of inquiry report, it would have been appropriate for the High Court to examine the averments made in the writ petition. A perusal of the writ petition would show that the petitioner has failed to lay any foundation to establish that any prejudice has been caused by the non supply of the inquiry report. No prejudice was actually caused to the respondent. There was no failure of justice in the facts and circumstances of this case by non supply of the inquiry report to the respondent. The punishment imposed on the respondent cannot be said to be disproportionate to the gravity of the charges proved against the respondent. The charges related to the conduct of the respondent in a financial institution whereby he procured pecuniary benefits for himself. Stop.